All right, well, good afternoon, everyone. My name is Rachel Dean. I am the Director of Systemic Investigations and Enforcement at Housing Opportunities Made Equal of Virginia. I'd like to welcome you to our webinar this afternoon on the rights of people with disabilities under the Fair Housing Laws. A couple of housekeeping items to note. There is a chat function in your webinar module, so if you have any questions, please feel free to type your question in the chat box, and we will try to address it if we have time at the end. I do hope to reserve about 20 minutes at the end of the presentation for questions. And if you have something that is related to a specific slide, don't hesitate to ask, and perhaps we can address that during the presentation as well. A little bit about Housing Opportunities Made Equal. We are a statewide fair housing agency in Virginia with a mission of ensuring equal access to housing for all people. And this webinar today will be a basic introduction to fair housing for people with disabilities, and we'll talk about some reasonable accommodations and modifications and hopefully get you squared away there. I'd like to thank Mike Burnett, our Strategic Communications Director, and Wes McQuillan, our AmeriCorps Vista for the year, for assistance with the webinar. And we'll get going. All right, just a disclaimer before we start into the meat of the webinar today. The information provided today is not legal advice, but if you do have any questions, you can give us a call, questions about specific situations with your clients. Also, today's presentation is made possible through a grant from HUD, the Fair Housing and Equal Opportunity Department in HUD. We're thankful to them for funding the webinar, and look forward to a great afternoon. So when we talk about disability rights, there's a couple of things that kind of make it important that we address disability rights right now in time. The 2012 Fair Housing Trends Report released by the National Fair Housing Alliance in April noted that disability-related complaints are the most common type of fair housing complaint nationwide. So among NAFA members, home is one of those members. Among NAFA members, 44.3% of complaints made to NAFA members related to disability discrimination, 46.5% of complaints filed with state FAP agencies related to disability discrimination, and 54.9% of all complaints that were filed with HUD FHEO in 2011 related to disability discrimination. So we know it's a very common form of discrimination going on. Further, the population of people with disabilities is growing, and I'm talking about both mental and physical disabilities. Last year it was estimated that approximately 1.5 million people in Virginia had a physical or mental disability, and those numbers are growing, and they're growing because of things like the age wave. Populations are simply getting older, they're living longer, and many are living with disabilities. Veterans coming home from war are coming home with injuries and disabilities so that they would need accommodations. So we know that these numbers are growing. Another thing to note is we need to talk about disability rights because unlawful discrimination is costly. It's costly both for the person being discriminated against as well as the apartment complexes or sales agents who are doing the discrimination. And finally, what we say at home is that where you live makes all the difference. So any type of discrimination is harmful to the community. When you're limited in your choice of where to live, you have lessened access to things like jobs, to things like transportation and other areas of opportunity in your life. So that's really why it's important to talk about disability. So a brief introduction to the fair housing laws. The Federal Fair Housing Act was passed in 1968. It was part of the civil rights movement of the late 1960s, and it protected race, color, national origin, and religion. Later on over the years, the protected classes of gender, familial status, and disability were added, and so we have those 7 protected classes today. The Virginia Fair Housing Law was enacted in 1971. It protects all of the aforementioned 7 protected classes, and it also adds a protected class of elderliness, which is defined as having attained the age of 55. Further, the Virginia Fair Housing Law is considered substantially equivalent to the federal Fair Housing Law. It means that HUD has decided that the Virginia Fair Housing Law really guarantees the same rights and procedures as the federal statute, and the Virginia Fair Housing Office is actually authorized by HUD to take fair housing complaints, and that's where a lot of the complaints home files actually go. So before we get into the details of disability discrimination, let's talk about what unlawful discrimination is in the housing context in general. There are many forms of discrimination, as you can see here, but really what you need is an act. You need the act made on the basis of one of the 7 protected classes, and you need a housing transaction. So really, if you look at these 3 columns here, you need one thing from each column, and then you have probably an unlawful form of discrimination. So what we see very often here at home is simple refusals to rent, refusals to make accommodations for people with disabilities. There's also discriminatory advertising out there. And also note that retaliation is an unlawful form of discrimination under the Act. So if you feel that your fair housing rights have been violated and you file a complaint, it's unlawful for a housing provider to then take adverse action against you because you tried to exercise those rights. There are some types of discrimination or types of choice making that housing providers do that are not covered by the Act. So for instance, if a housing provider decides not to rent to smokers or illegal drug users, that's not actually covered by the fair housing laws. Housing providers can also make discriminatory choices based on whether someone has a criminal record or doesn't meet the qualifications of the housing in another way. So we are really focused, again, on these protected classes under the fair housing laws. You see them here on the left: race, color, national origin, religion, gender, familial status, disability, and elderliness. All right, so bringing it specifically to the issue of disability discrimination under the Fair Housing Law, we first have to talk about what qualifies as a disability under the Fair Housing Act. And so the Fair Housing Act and the regulations related to the Act state that a disability is a physical or mental impairment. It can either be obvious or invisible, but it has to substantially limit one or more major life activities. It can also include individuals who have a record of having had this disability, even if it's not currently an impairment for them. So again, physical or mental impairment, it has to substantially limit one or more major life activities. And what's important to note about this disability definition is that it doesn't have to come with some sort of medical diagnosis. As long as you have something that's substantially limiting your daily life activities, you may qualify as having a disability under the Fair Housing Law. So the disability protections under the Fair Housing Law work in 2 ways. People with disabilities are protected just as people in other protected classes are. So it's unlawful to refuse to rent to someone with a disability. It's unlawful to pose different terms and conditions on someone because of their status as having a disability. But there are also additional protections under both the Virginia Fair Housing Law and the Federal Fair Housing Act that relate to people with disabilities and their right to make requests to sort of level the playing field in their housing and to allow their housing to meet their needs regardless of having a disability. So the Act guarantees the right to make a reasonable accommodation, or excuse me, to request a reasonable accommodation and to request a reasonable modification. And it's important to know that these are extra protections for persons with disabilities, again, to allow them to enjoy their housing like anyone else would. So when we talk about reasonable accommodations and reasonable modifications, what they are is sort of a change in policy, rules, or other terms and conditions of housing that allow a person with disability to enjoy their housing like anyone else. So a common reasonable accommodation request would be to ask for a designated accessible parking space. It could be to ask that they be allowed to have a service animal and that pet fees for that service animal be waived. Reasonable modification requests are things that would require a structural change to the property. So we're talking about things like installing grab bars into showers, about installing ramps into a housing complex to make it accessible for someone with a wheelchair. And we'll get into a little bit of the specifics of those types of requests in a little while. But it's important to know that almost anyone can make the request for the person with a disability in the housing. So the person could make the request for himself or herself. A family member could make the request. A roommate or co-tenant of the person with a disability could make the request, or really someone else acting on that person's behalf. So a social worker, an attorney, a guardian ad litem, that type of thing. These are all people who have the ability to make requests for accommodations and modifications under the Act. Requests for reasonable accommodations and modifications don't have to be written. Verbal requests are okay. We always recommend that they are written because that helps for record keeping later. And the person making the request is not required to use the term reasonable accommodation or reasonable modification. What's really important in the request is to show that the accommodation requested relates to the disability and allows the person to fully enjoy his or her housing. In addition, landlords are not allowed, or other housing providers are not allowed to request or require verification of a person's disability if that disability is obvious. So an example I always use is someone who, for instance, has a wheelchair, who is requesting that they be allowed to install a wheelchair ramp to gain access to the unit. The connection there between the wheelchair and the modification requested is pretty obvious, and the landlord would not be allowed to require verification of the disability in those circumstances. Further, once an accommodation or modification request is made, a resident is entitled to a prompt response from the landlord or other housing provider. So that response, I usually say, needs to be made within 2 weeks of the original request. And also, under the fair housing laws, no additional fees for processing these requests can be charged. We talked a little bit about what the housing provider could require in terms of verification, and I noted that if a disability is is obvious or visible, then the housing provider can't require verification of a disability. However, in some cases, if the disability is not obvious, there are some hidden disabilities, then the landlord can require verification. However, the verification can't be onerous. So a simple doctor's note would do, or a simple note from a social worker or other counselor working with that client would also be appropriate. Now, when we talk about accommodations and modifications, the key word here is reasonable. So a landlord or other housing provider needs to provide things that are reasonable. They are allowed to deny requests if the request would impose an undue financial or administrative burden to the landlord or housing provider, would fundamentally alter programs or services in the housing, or if there's just no connection between the disability and the request. So if someone has a disability and they're asking, something that's completely unrelated to the housing there, then that wouldn't be a reasonable thing to ask, and the landlord would be within their rights to deny that request. So verifications for disability when you're making RA or RM requests can include any of the following here. And as I said before, it's not you're not just limited to things like doctor's notes. If you've already have been receiving Social Security benefits for your disability, proof of receipt of those benefits would suffice. If you have a social worker or other non-medical service provider working with you, proof of that would suffice as well, and that person could write the verification letter. Also, third-party knowledge, so having someone affirm that yes, they know you, and yes, in fact, you do have a disability, that can also suffice in some cases. Okay, so let's start with a discussion of the details of reasonable modifications. So as I said before, modifications are physical or structural changes to a property, and I used the example of grab bar installations, installing wheelchair ramps, things that actually require a physical modification. So the thing to note about modifications is that they often aren't going to be paid for by the person who is providing the request. So the landlord is usually not going to be on the hook to provide this type of, the cost of this type of thing. There are some other rules for publicly funded housing where they are required to make the modifications at their cost. But in most cases in private housing, the person with the disability who's making the request will need to pay for the modifications. However, the landlord or housing provider needs to allow those modifications to be made, and there are very few restrictions the landlord or housing provider can put on that modification. The provider rights here are that they can ensure that the work will be done properly. They can ask the resident to obtain building permits if needed. And, of course, they can require the resident to pay for the modifications. This is often a point of contention in some of the complaints that we hear, but a housing provider can ask the resident to restore the unit to its former status, but not in common use areas. So if someone has installed a ramp or widened a door into common use areas where others may need that modification, the housing provider cannot ask the resident to change it back to the way it was. The housing provider can also ask the person requesting for the accommodation to set aside money to pay for the restoration of it to its previous status. When we talk about reasonable accommodations, we're talking about things that are not going to be physical or structural changes. They're actually changes in the policies of a housing provider. And it's unlawful for a housing provider to refuse to make these changes when the accommodation is necessary to afford the person equal opportunity to use and enjoy their dwelling. So these are things, again, like requesting a parking space. It could be requesting that you're allowed to pay your rent after you receive your disability benefits for the month. It could also be allowing service animals in. There are any number of accommodations that can be made to allow a person with a disability to enjoy their dwelling like anyone else. I have a couple of examples on this screen. One of the most common RAs that we see here at home is actually asking to have a designated accessible parking space. In some apartment complexes, an apartment comes with a parking space. It might not be the most accessible place to park, so it is an accommodation to provide that. Another common accommodation request we see here at home is for people who have a disability and the disability worsens, or there's someone with a new disability and they just can't use their apartment anymore. Perhaps they're on the third floor of the building, there's no elevator, and due to the disability they just can't get up and down the stairs. We have been working with the Virginia Fair Housing Office on a number of these cases, and the common understanding is that allowing a tenant to end a lease early because of a disability is actually a service or policy of the lease and the housing provider. So it would count as a reasonable accommodation in these circumstances. The third most common thing that we see is people asking to have the no pets rule waived to allow a service animal or other type of assistive animal into an apartment complex and have that no pets rule waived and have pet fees waived. The housing provider does have responsibilities to the person making the reasonable accommodation request. They are obligated to respond promptly. Again, within 2 weeks is reasonable. There's also a requirement on housing providers to start a sort of a negotiation process if they're unable to grant the accommodation that is initially requested. So if a housing provider sees that it's just going to be an undue financial burden to provide that accommodation that's requested, they just can't afford it, perhaps they're a very small housing provider, they do have an obligation to start an interactive process with the person who has a disability to try to see if there's a more reasonable accommodation that can be made. What I always tell housing providers who come to ask for advice is that they should really document all their efforts to work toward a compromise. We know that many housing providers across Virginia are very willing to work with clients who have disabilities, and they just need to keep everything documented so that they can show that they've done their obligations. Okay, as I said, service animals are a popular issue here in Virginia. what I always try to impart to people that if a person needs an animal for a disability-related reason, it's not going to be considered a pet in the housing. It's a service animal. And service animals can provide assistance to people with both mental and physical disabilities. There are a wide array of service animals out there. And in the fair housing context, and this is different from the context of the Americans with Disabilities Act, in the fair housing context, the service animal does not need to be licensed or certified or trained in any way as a, quote, assistive animal. It suffices that the animal is trained by the person with a disability to respond to the specific needs of that person. And that point comes up a lot when we talk about emotional support animals, which I think are a little bit less well known than animals that may assist people with mobility impairments or other physical disabilities. But again, under the fair housing laws, it's not required that service animals have special certification or training. Now, housing providers can require that the animal is, they have all of their shots, they're up to date with the animal code for that jurisdiction, they've been immunized against rabies, that type of thing, but no additional certification or licensure is required. So when someone has a service animal and they request an accommodation, again, it's not considered a pet, so pet deposits and pet fees, monthly pet rent, that type of thing, those should all be waived. In addition, size and breed restrictions should be waived. So I know a lot of multifamily housing has restrictions on very large dogs, for instance, or on things like maybe snakes or mice, that type of thing. Those restrictions need to be waived. In the fair housing context, almost any animal can count as a service animal. There are service dogs, service cats, service rabbits, that type of thing. And it's not just the sort of, I guess, traditional notion of, I guess, a dog that would help someone perhaps with a mobility or vision impairment. There's really a wide array of service animals out there. A common question from multifamily housing managers is, okay, I understand, but what about if I have an animal that's disruptive? I've allowed the service animal to come and assist the person with a disability, but the animal just, it bothers neighbors, maybe it's a dog that barks. What do I do in that situation to accommodate the person but still make sure that this animal isn't disrupting the neighbors? First thing to do, and again, here's where my advice to always keep everything in writing comes in handy. The first thing to do is to issue a written warning to allow the behavior to be modified. So you should let the tenant know, your service animal has caused a disruption, and please address the matter. You can also request that the animal be sent to obedience training to try to get that animal to change its behavior. Or perhaps suggest that a different animal that could also meet the needs of the person with a disability be obtained. Again, some advice for housing providers here. So what I always tell people is that you don't want to talk about accommodations related to the specific person, but talk about policies that you have. So if you have a prospective tenant who comes up and says, I have a service animal, what do I need to do? I don't want to comply with the no pets rule. You could say something very general like this. Fair Housing Act requires us to make accommodations. If you believe you qualify, let's schedule a confidential meeting to discuss. And that really goes for any type of accommodation or modification request. Let's go back. We did have one question about animals that might cause damage to an apartment or home. Really, from what I can tell, state law is really going to apply there. So, reasonable wear and tear on an apartment is usually covered by the landlord. It's the landlord's responsibility to take care of reasonable wear and tear. If you have something that goes above and beyond that, there aren't going to be accommodations for that type of thing. So the animals that are assisting people with disabilities, again, still need to follow the rules of living in the community, and that could include damages and that type of thing. So there could be some liability on the person with a disability for damages that are caused by the service animal. Okay, so requesting a reasonable accommodation is pretty straightforward, and again, it doesn't have to be in writing, but we always ask that people put things in writing because, again, it makes it easier for record keeping in the future, and if anything goes wrong, you always want to have that written document. But so when you're requesting a reasonable accommodation or modification, the first thing you want to establish in writing is that you are a person with a disability. You do not have to state the nature of your disability. You don't have to give a medical diagnosis, but you just need to state that you are a disability, and in fact that disability affects your ability to do day-to-day life activities. You should state where you live, so your apartment unit number, and who is responsible for the building. So you're writing to the landlord, the property manager, and you're going to say, I live in this unit, and this unit is managed by you. So you're establishing that connection between you and the housing provider. And then you want to describe the policy rule or the structural barrier that is actually problematic for you. So in a parking situation, you could say, I have an assigned parking space. It is down the hill. There's not a curb cut, and I can't get in there with my walker. And so I'm asking that you switch me to a different parking space. This would be an accommodation to a rule. I'm asking that you switch me to a parking space, give me an assigned parking space so that I can access it like anyone else. You also want to describe how the policy or barrier interferes with your needs. So what I've just done there is talk about specifically, I can't get to my car, I can't get to work, I can't get to grocery shopping. So you want to be very specific there with that problematic area for you. You want to describe the change that you're seeking in the policy or rule or barrier, and also cite the law that protects your rights. And in Virginia, you would just say that the Virginia Fair Housing Law protects my right to have a reasonable accommodation made. You could say the Federal Fair Housing Law protects my right to have a reasonable accommodation. You always want to give a date for the housing provider to respond. So again, within, I'd say 10 to 14 days is a reasonable amount of time for that response to come. Always sign and date the request and keep a copy for yourself, and then send the request via certified mail or hand deliver it. If you hand deliver it, make sure you have a witness with you that could affirm that yes, you did send over that request. So what happens when, unfortunately, your fair housing rights may be violated, or you have reasonable accommodation or modification requests that aren't granted? You do have the right to file a fair housing lawsuit in state court or in federal court. If you take that route, you have a 2-year statute of limitations to make your complaint known. You also have the option to file an administrative complaint with the Virginia Fair Housing Office or with the Department of Housing and Urban Development at the federal level. Administrative complaints have a 1-year statute of limitations, and they are a free process. So what will happen if you file with the Virginia Fair Housing Office, which is our state FAP agency, is that an investigator will be assigned to your case. He or she will go talk to everyone who is involved with what you said happened, gather information, and present it to the Fair Housing Board for a decision. At the same time, you will also enter a conciliation process to try to work things out with the housing provider. It is voluntary, non-mandatory, but they do offer a free conciliation process for you as well, and that is a very similar situation with HUD. Anyone who is a victim of discrimination under the fair housing laws can file a complaint. So it could be the person with a disability, his or her family members who live in the household, children, roommates, anyone who has been injured in some way by the discriminatory actions. Guests or visitors can also file fair housing complaints. So if there is a visitor who has accessibility issues with a housing provider or getting into the housing, he or she may also be able to file a complaint. Housing providers and real estate agents themselves can file fair housing complaints if they can show injury because of some act of discrimination. And finally, organizations like HOME or like the National Fair Housing Alliance also are able to file complaints if they can show evidence of discrimination that injured their mission as an organization. And that was established by the Supreme Court case that you see here. Potential respondents are many. They are varied. They can be the classic situation of the landlord or property manager, but they can also be any of the institutions you see here. You can file fair housing complaints against lenders, against neighbors who are harassing you because of your disability or because of some other protected class. You can even file fair housing complaints against newspapers for publishing discriminatory advertisements. I've already talked a little bit about the administrative process, but just know again that it is free. It's a very good process, and I think many clients have been happy with it. And HOME does often assist clients with filing administrative complaints. So if you have a client who you think may have a discrimination problem under the Fair Housing Act, you can always call HOME and see if we'd be able to assist with drafting that complaint and navigating through the administrative process with you. Again, when you start the complaint process, you do have the option of conciliation, and if it fails, your complaint will go before the Fair Housing Board anyway, so conciliation is not mandatory. When the Fair Housing Board in Virginia gets a complaint from an investigator, they will actually take a vote, and they will decide whether there's reasonable cause to believe that housing discrimination occurred or no reasonable cause. If reasonable cause is the decision, then the case actually goes to the Attorney General's office. It's called a charge, and then the Attorney General's office in Virginia will actually litigate the case in state court. But there are several procedures to go through before it gets to that point. So when you have a fair housing complaint and it goes to court, there are several penalties that can be assessed. Of course, you can always be compensated for the damages you had. Any money that you spent because of discrimination, you can be compensated for emotional injury as well as financial injury. There are civil penalties that can be assessed. Attorney's fees can be awarded to the plaintiff in these cases. There could also be injunctions awarded. So things like, telling a landlord that he or she has to let this person into their housing to rent, or telling the landlord you have to make this reasonable accommodation. Many housing providers are required to attend fair housing training if there has been a ruling against them for discrimination. And in some cases, they can be subject to criminal prosecution, but that's very rare. I've seen a lot of questions here, so I want to actually just answer some of the questions. And if you have any questions, please type them now because we're going to wrap this up and go to more of a question and answer format. We did have a question about breed restrictions, such as pit bulls. I haven't seen a lot of pit bull cases. It looks like the commenter here has seen some. But in my understanding and in my experience, breed restrictions should be waived. So a common restriction is pit bulls, German shepherds, other large animals. Those should be waived. Unless there is some sort of statute in that jurisdiction where there's a breed that is outlawed, the housing provider should waive the breed restrictions for a service animal and allow the person with a service animal to have that, and it's not considered a pet. We also had a question okay, so we had some questions about how a property manager or other housing provider should address a resident service animal that breaches a lease policies. That's really going to be on a case-by-case basis, and it depends on the lease policy. So sometimes there can be an accommodation to that policy or that lease rule that should be made, and sometimes that's actually just completely unreasonable. So my advice to housing providers would be, before going on with legal procedures such as an unlawful detainer or eviction, the housing provider should approach the person with a disability, have a meeting, have witnesses present, and try to figure out if there's another type of accommodation that can be made. Sometimes people with disabilities, they need a service animal, but they also have difficulty doing other things in their home. They may have difficulty fixing damage that the animal causes, that type of thing. So it may be necessary to give them a little bit more time to address those lease violations before the unlawful detainer process is started. So I would always advise to approach the person, try to work something out as an accommodation before going ahead with legal procedures. But of course, we know that under state law, if there's a lease violation, property managers and landlords do have the right to go ahead and take legal proceedings and address that. Are there any other questions or clarifications that can be made? While we're waiting for a couple questions to address them, I do want to note that HOME will be having a webinar on November 20th at the same time, 2 p.m. This webinar will address mortgage rescue scams, and these are scams that are targeted at people who are facing foreclosure and looking for a way out, looking for a way to modify their loan or avoid foreclosure. And we've seen scam companies cropping up all across the country who are taking advantage of these people and offering services that are often quite expensive and that are not always legal. So our Mortgage Rescue Scams webinar will take place on Tuesday, November 20th. If you have a question, please type it in the chat box. I've actually turned off microphones for all the attendees so we don't have a lot of crosstalk. Okay, we do have a question about tenants or other clients who are requesting multiple service animals, and you have a policy that allows for only one. Again, that's a case-by-case basis. I have seen situations where someone has more than one service animal, and each animal actually addresses a different need of the person with a disability. So perhaps a person has multiple disabilities or has a disability that manifests in multiple ways, and you have two different animals who are attending to two different needs, and that would be a reasonable accommodation that should be granted. But again, it's a case-by-case basis. If you have someone requesting multiple companion animals, you need to follow the same process and engage with them in that interactive dialogue. If you feel that the two animals or more than one animal is too much for you to accommodate, you need to engage in that interactive process and keep records on that. Please know that HOME, we do assist victims of discrimination, but we are also here to provide assistance to housing providers and other property managers to talk about policies that you may have in place. We have some sample non-discrimination policies. So if you'd like to talk to someone at HOME about that, then please let us know. We'd be happy to help you. We have some contact information here. Our website is pretty easy to remember. It's phonehome.org, like ET phone home. And you can contact us there and we'd be happy to assist you. We have a question that I think is a great question. It's a very common question. Someone has asked about rental payments and whether you can make an accommodation or whether you can request an accommodation to actually have your rent not due until the date of the month that you receive your disability benefit check. And yes, that is an accommodation that should be made. Some people have disability benefits as their only form of income, and that is the income that they are using to pay their rent. And it's often difficult if your SSDI check doesn't get to you until the 5th of the month. You're scrambling to try to get your rent in before it's considered late. So that would be a change in policy for the person with a disability to move the rent payment date to the day that they actually receive those benefits so that they can get month to month without scrambling, worrying about when their benefit check will arrive to pay that rent. Another question, and this relates to something I noted before, if there is someone who maybe doesn't have a disability and they suddenly do, they have some sort of disability or illness that requires them to move out of the apartment complex or other housing because they simply can't use it anymore or can't use it in the same way, then you could request a reasonable accommodation to be let out of the lease with no charge. But in most cases, you would also need to show that, because of the disability or because of the illness, the person just isn't able to use the housing. They're not able to use it the way they once were. Perhaps the disability has worsened. They can't use stairs anymore. That type of thing. That would be a perfectly reasonable accommodation. Okay, someone has also asked a very good question about what is really unreasonable or undue financial burden. There is no, again, this case-by-case basis, so it's going to depend on what an undue financial burden is for the housing provider. There's no established threshold or percentage of cost, but this is going to be case-by-case basis. I'm seeing several questions that are very specific to clients, and so I'd invite you, if you have something if you have a current client and that client needs accommodations, please contact home. Our number is 804-354-0641, and one of our fair housing counselors will actually discuss with you the specifics of your client situation and talk about what your client can do. Again, our number is 804-354-0641. Bear with me, I'm still trying to catch up on these questions. Okay, so great question. I am seeing a question on hoarding. And I know that hoarding is a very popular topic right now. It is a common problem that housing providers have. There is not a lot of established rules on hoarding and accommodating people who have a hoarding disorder. In some cases, the hoarding behavior is a disability in and of itself. Sometimes it's a symptom of a mental disability, like someone who has like a compulsive or obsessive compulsive disorder or other mental disability. And it's tough to draw the line there. So one, I would tell housing providers who feel that they may have hoarding problems to have disability policies in place so that when it becomes time to request a reasonable accommodation, you have a process for approving or denying that in writing. With hoarding, it's a tough call. I draw the line, as many jurisdictions do, at when hoarding becomes a health and safety hazard. So we know that with local laws, you need to have safe entrance and egress. You need to have walkways so that a person can get through the building, so that firefighters or other emergency service personnel can get through the unit. And it's looking like, okay, someone with limited access in their apartment, that could be a safety issue where you would not be required to accommodate that person. But, just because someone has stacks and stacks of newspapers or knickknacks or other things that they're collecting, they may border on hoarding, but if they're not blocking safe entrance and egress, you may need to accommodate them. Also, with people who have hoarding disorder, my experience is that it often takes them longer to address their problem. So a reasonable accommodation may be, okay, you've gotten to the point where we're looking like we may evict, but we will give you a month or two to try to get things back in shape. So these are very difficult situations. I urge you to talk to your own attorney and to always keep things in writing to make sure that the hoarding is kept under control, but you're still accommodating that disability. Okay, I do have, again, this word reasonable is a tricky word. Someone has asked, Okay, so once you have approved an RA or a reasonable modification, what's a reasonable time frame for completing that accommodation or modification? And of course, that's going to depend on the circumstances. I would say a reasonable time frame for something like assigning a new parking space, maybe 10 to 14 days, depending on how full your parking lot is, how quickly you can get in there and have someone repaint lines. I think 10 to 14 days is reasonable. Something like installing installing a wheelchair ramp or grab bars, if the tenant's going to do that, you should approve the modification request as soon as possible, which then allows the tenant to make the modification as soon as possible. So again, reasonable under the circumstances. It's always going to depend on the situation that you're in, how big your apartment complex is, what other requests you have in the pipeline. But for things like simple policy or rule changes, again, 10 to 14 days I think is reasonable. That allows you to make the necessary changes, have them approved by your manager or your attorney, and notify the person that the accommodation has been completed. Okay, I am seeing more specific, very specific questions, and some of them are going to be in a case-by-case basis where I don't want to answer without knowing all the facts of the situation. So if you do have those questions, please email me or visit us at phonehome.org. My email is here on the screen, and we can try to assist you getting you some copies of the statute and some other guidance. If you go to your materials list, we have attached a very helpful statement from HUD and the Department of Justice. There is one on reasonable accommodations and one on reasonable modifications. And some of the situations that have been brought up in these questions are addressed in those statements. So again, in your materials section, you should see the HUD-DOJ joint statements. One is on reasonable accommodations, one is on reasonable modifications. And those are very helpful. We've also attached Home's own reasonable accommodation and modification guide. This is something for service providers. Would be helpful for you to distribute to your clients. It walks them through the request process, and there are also some template letters in there for clients to use. There's a copy of the presentation here as well, so you can refer to that, and again, my contact information is here. I've also attached some helpful guidance from HUD on service animals. HUD has a very helpful disability rights program. They've actually devoted millions of dollars to addressing disability rights. So if you visit HUD's website at hud.gov, there are some very helpful documents there as well. Okay, well, again, I'm not seeing any other questions here that I can address on a general basis without knowing more specifics. So you have my email address. I thank you so much for attending our webinar. Remember that our next webinar will be in a few weeks on mortgage rescue scams. There's more information that we will be posting at phonehome.org. And thank you for attending.